Hello everyone, my name is Eduardo Gaban and I am an antitrust lawyer in Brazil. I'm here to talk about the new Brazilian pre-merger control system. Accordingly, this presentation is split in the following sections. First of all, I'm going to talk about general recent developments of competition and antitrust law in Brazil. Secondly, I will present a detailed description of the new Brazilian antitrust law, law number 12529/2011, and its regulations. Next, I'm going to talk about merger control procedures and rules under the new regime. Finally, I will present some remarkable conclusions about the new system, as well as some numbers concerning merger control in Brazil. I hope you enjoy it. In the recent years, antitrust enforcement in Brazil has kept its consolidation and evolution trend. As one of the BRIC economies, it goes without saying that the economic growth in the country brings additional components to the Brazilian context. More complex transactions submitted to merger control last year, 2012, as well as more complex and veiled antitrust investigations have contributed to increase the visibility and relevance of the Brazilian System for Economic Defense, SBDC, worldwide, especially of the Administrative Council for Economic Defense, CADE, the main antitrust agency in Brazil. Keeping up with this trend, CADE has been able to increase its efficiency, transparency, technical qualification, and staff, which reflected the evolving results during 2011-2012. According to CADE's 2011 annual report, the number of acts of concentration, merger filings, saw a 57.5% increase in comparison with the number registered in 2005. Since 2005, CADE has seen an increase in the number of technical staff, who were also given more responsibility, resulting in a rise in the number of cases analyzed per year, which rose from 666 in 2005 to 814 in 2011, as well as the average time taken within CADE to analyze merger filings, which went from 81 days in 2005 to 47 days in 2011. In addition, the staff increase, the reformulation, and the enhancement of cooperation within SBDC eliminated overlapping activities and granted a significant reduction on the average length of analysis of merger filings, from 252 days in 2005 to 147 days in 2011. The depth and strength of the decisions can also be regarded as an achievement. In May 2012, CADE authorized asset swap between Brazil Foods and Marfrig Alimentos, in compliance with heavy restrictions of selling assets assumed by BRF, Brazil Foods, in the merger between Sadia and Perdigão, decided in July 2011, involving approximately 35% of the party's production capacity in Brazil, comprising production facilities, distribution centers, and an important portfolio of products and brands. Also, the authority cleared the transaction between the airline companies LAM and TEM, subject to the swap with a competitor of some slots and infrastructure in the São Paulo International Airport, and the exit of one of the worldwide airline companies' alliances, One World or Star Alliance. In the steel sector, CADE has granted an injunction to prevent completion of the acquisition by the Brazilian Companhia Siderúrgica Nacional, CSN, of additional stakes in its competitor, Usiminas, Usina Siderúrgica de Minas Gerais. Accordingly, CADE ordered that until a final decision is rendered and subject to the imposition of fines of 10 million reais plus a daily fine of 10,000 reais for violation, CSN would not be allowed to appoint any member to the board of directors or any other management board of Usiminas. Neither any company of CSN's economic group should have access to competitively sensitive information, nor exercise any management or political rights over Usiminas, for example, voting rights in general shareholders' meetings. Additionally, CADE has executed some agreements to preserve reversibility of transactions, known as APROs. in important cases. In order to maintain the competitive environment, as well as to keep the parties independent until a final decision is reached. This was the case of the merger between the Brazilian airline company Gol and Webjet, as well as the transaction concerning the acquisition of Diagnósticos da América S.A., DASA, of control over MD1 Diagnósticos S.A., and the subsequent acquisition by Amil Group of participation on DASA's shares in the health assistance and diagnosis service sector. Also, CADE has recommended a final decision by CADE's tribunal is pending. The rejection of the purchase of companies that integrate Aliança Administração de Benefícios and GA Consultoria by Qualicorp in the sector of healthcare benefits administration market. According to the authority, the acquisition would lead to reduction in competition and thus reducing existing benefits and consumer welfare in that service. In the same healthcare segment, healthcare services and insurance plans, CADE rendered a similar opinion on the acquisition by Unimed Franca of the regional hospital of Franca and its healthcare insurance plan. Franca is a city of the state of São Paulo. In addition to those opinions, CADE blocked the acquisition by Brazil Foods of assets of production and slaughter of pork by Duc Frango Sul S.A. Besides this, CADE was chosen for the first time to host in Brazil the annual conference of the International Competition Network, ICN. CADE also celebrated its 50th anniversary in 2012. In other global developments, CADE participated in the second International BRICS Conference in China. Furthermore, it held meetings with French competition authorities as well as with the Brazilian Cooperation Agency, Brazilian Ministry of Foreign Affairs, both of which resulted in the execution of more international cooperation agreements. Finally, the most expected and commented on development of antitrust in Brazil concerns the enactment of the new Brazilian antitrust law, which brings mixed feelings of enthusiasm and skepticism among competition and antitrust players, both in public and private sides. Some of its highlights are explored below. This was an overall description of competitive environment in Brazil. Now, let's talk about the main topic of this video. On 3rd November 2011, the new Brazilian antitrust law, ANBAL, was enacted. In short, the main changes brought by this new law are related to the organic structure of the system and to the merger control. The, quote, SuperCADE, as it's usually called, is now composed of 3 bodies operating within the same structure. The Administrative Tribunal, which takes on CADE's current roles and powers, delivering judgments of all cases under the antitrust law. The General Superintendents, GS, which replaces SDE's and CI's functions, both on mergers and behavior controls, and the Department of Economic Studies, DEE, which will support both the Tribunal and the GS on complex economic matters. CADE's Attorney General Office will keep its main role in supporting to SuperCADE's decision in courts. CI will restrict its function to competition advocacy. The main structural changes can be seen in Table 1 at the end of my book, Antitrust Law in Brazil, Walters Kluwer, 2011. The new law was enforced on 30th May 2012 and has been applied to all cases held thereafter. In addition to the organic restructuring, the new law brings a commitment of reinforcements of more than 200 staff who will be fully dedicated to case analysis within the SBDC. As of 29th May 2012, this additional task force has been approved by President Dilma Rousseff via Decree number 7338. It was not immediately implemented, but a gradual implementation of the task force is expected within an estimate of over a year until it's finally implemented in full. Other than structural matters, the new law brings the pre-merger notification system into the Brazilian antitrust arena, making it closer to the EU and to the US merger control systems. With regard to the merger control procedures and rules under the new law, the general concept of, quote, concentration is very broad. Article 88 of the new law refers to, quote, any form of market concentration, end quote, including in its scope cooperative agreements, contracts, informal agreements, and other agreements. In the new system, aimed at absorbing the international model, US and EU, to control structures, the new law implemented the prior analysis or prior control, ex ante or a priori, of business transaction. And this prior control, Article 88, sets forth that the transactions that meet the revenue criterion, the largest party of its economic group has a gross revenue of at least 750 million reais, and the smallest party or its economic group has at least 75 million reais, both registered in Brazil in the year prior to the transaction. These triggering values were increased by means of the Ministry of Justice and Ministry of Finance Joint Regulation number 992 as of 30th May 2012. Shall be given mandatory submission and cannot be consummated before CADE's final ruling. Something similar to the non-concept of, quote, prior consent, end quote, from the Brazilian regulated sectors such as telecommunications and transports. Therefore, in addition to the risk related to the merits of the deal, the risk of CAD approving the deal with restrictions or even rejecting the deal, the economic players have to face what is internationally known as gun jumping. According to the international experience, gun jumping is the practice of consummating the deal or closing the deal in opposition to signing the deal before the antitrust agency manifests itself for or against it. The international experience, which will probably serve as grounds for CADE's case law, lists some examples of gun jumping. Reversible measures, or measures hard to reverse, such as the allocation of clients, interruption of competitive marketing between the parties, unification of management, sharing of price information, production capacity and trade strategies. Case GameStar/TV Guide 2003 and Qualcomm Flareon 2006, both cases in the US. Other examples: actions that change incentives between players, such as the commercialization of products of the acquired company by the acquiring company, like case Bertelsmann-Kirsch in Premier 1998 in the EU. Other examples: unification of power within companies, such as failing to make business and offering discounts, arising from the possible closing of the deal, case Computer Associates Plantium Technology 1999 in the US. Or even sharing trade secrets, for example, client portfolio prices, strategies, and others, for reasons beyond a due diligence question. Case GameStar TV Guide 2003 in the US. In addition to the high fine, varying from 6,000 reais to 60 million reais, should a deal be consummated before receiving CADE's decision, and given the nature of the factors considered to consummate a deal, the deals could be declared as null and the parties can undergo an investigation. For example, in horizontal concentrations deals between competitors, the sharing of information such as client portfolio, prices, etc., may immediately change the incentives of the parties to compete between themselves. In this sense, a good way to avoid the risk would be to always consider the following question: what would you tell your competitor if there was no ongoing deal? As the authorities in charge of governing the matter have already stated that they will leave it to the case law to find the limits for gun jumping, Brazil, in the first period of enforcement of the new law, will face a potentially difficult process of growth and cultural change in which the risk of gun jumping will possibly be bigger at times than the risk of transaction itself. For this reason, it is advisable that during this initial period of the new law enforcement, the economic players adopt, whenever possible, more conservative measures to ensure that deals that have been notified to the SBDC are not consummated. Please note that the new law is only applicable to transactions executed from May 29th, 2012 onwards. These transactions, which had their first binding document signed on or before 28th May 2012, are subject to the previous system, ex post merger control, provided by Law number 884/94 and therefore shall be submitted to CADE until 19th June 2012. Ongoing transactions which were signed after 29th May, however, fall within the scope of the new law and must be previously notified accordingly to the new merger control system and applicable regulation. Moreover, on the very first day of the enforcement of the new law, CADE has passed 4 new regulations. The first is CADE's new internal regulation, which provides for CADE's structure and procedural aspects of the application of the new law. The second regulates the submission of transactions to merger control, the new Brazilian antitrust merger filing forms. The third provides on the imposition of fines for antitrust violations. The fourth establishes formal and material criteria to file independent technical opinions in complex merger and conduct cases. The main provisions comprises the following subjects: notification thresholds, concept of an economic group for the purposes of calculating the notification thresholds, new merger filing forms, transactions involving a public offering and tacit approval. I will describe each one of these aspects now. Concerning notification thresholds, transactions that meet the notification thresholds, 750 million reais on one side and 75 million reais on the other side, must be submitted to merger control only if they result in acquisition of control, or they do not result in the acquisition of control, but directly or indirectly. In the case of non-competing parties, the acquired interest is equal or higher than 20% of the seller's share capital, or the purchaser already holds more than 20% of the share capital of the seller and acquires an additional stake of 20% or more of the seller's capital. And in the case of competing parties, for example, holding a horizontal relationship, the acquired interest is equal or higher than 5% of the seller's share capital, or the purchaser already holds more than 5% of the share capital of the seller and acquires an additional stake of 5% or more of the seller's capital. And in the case of an additional stake acquired by a controlling entity, the acquired interest is equal or higher than 20% of the seller's capital. It is worth noting that for the purposes of calculating the notification thresholds, CADE regulated the concept of economic group, which companies' turnover must be added. Hence, companies belong to the same economic group if they are under the same direct or indirect control, or if at least 20% of the share capital is held by a company under direct or indirect common control. Private equity funds, managing funds, investment funds, which are under the same management, and those in which their shareholders have a minimum of 20% stake are part of the same economic group. This also includes the portfolio companies whose share capital is held by a private equity fund at an interest rate of 20% or more. With respect to the submission of transactions, the changes in the merger control regime also resulted in new merger filing forms. Now, there are 2 new merger filing forms, both inspired in the volume and content of the ones required in the US and the EU. One of them is applicable to transactions that are not able to raise competition concerns and are likely to be analyzed under the fast-track procedure. The other, longer and more thorough, is applicable to complex transactions. CADE also regulated a specific situation, transactions involving public offerings. In this case, the transaction may be notified after the offer is published and its completion does not depend on CADE's prior approval. However, the acquirer is prohibited to enforce any, quote, political rights, such as voting rights, linked to the acquired interest until the transaction is cleared by CADE. Please note that mandatory public offerings for cancelling the registration of public trade companies or raising stakes by the controlling entity must not be submitted to merger control. Back to general aspects of merger procedures. Considering that new ex-ante merger control system could result in late decisions in view of the parties' interest in negotiating a transaction, CADE created a preliminary injunction clearance of transactions. Therefore, it was stated that transactions that are unlikely to raise competition concerns may be, quote, preliminarily cleared, end quote, by CAD upon request by notifying parties. In the case that the analysis waiting period is likely to cause reversible and substantial financial damages to the parties. The adoption of closing measures by the parties is irreversible, and preliminary clearance will have no negative effect on the competition environment. Such a preliminary approval may be granted in up to 60 days after the transaction's notification to CADE, and may be modified or cancelled by CADE, as the case may be, being valid up to a final ruling is rendered. By the same token, CADE established that should a final ruling in a merger control case is not rendered within the maximum deadline of 330 days, the transaction is considered tacitly cleared. Well, these were my considerations on new Brazilian pre-merger control system. Now, I will move to some final personal considerations about the new regime. In the 2010 OECD peer review, it was concluded that the Brazilian competition policy has registered a constant and notable progress, becoming more efficient, especially in merger review. In the very same review, it has been said that although the Brazilian system is far from perfection, it is doing very well. Based on these comments, the SBDC currently faces some very important challenges for the future. Due to the enactment of the new law, CAD members have faced an intense transition phase in implementing the new law and CAD's new structure. Firstly, there is an effort made to applying the new rules and maintaining CAD's case law and practices that are compatible with the new system. In this regard, the first impressions are that CAD is prepared for the future. Part of the case law concerning relevant influence, control and private equity funds has already been incorporated into the new regulations. Additionally, new service positions have already been approved by President Dilma Rousseff. However, only few of them have already been fulfilled by recent appointments. This means that CAD still suffers with lack of sufficient qualified personnel to carry out the analysis of the cases. Notwithstanding, CAD seems to be showing effective activity, as, for instance, transactions submitted to merger control and analyzed under the fast-track procedure have been cleared in approximately 20 days. In sum, there were great expectations for the approval of the new antitrust law. Now that it has been enacted, there are greater expectations and guessings on the new law's effects and the new expertise to be acquired. Whatever the results may be, it is known that, besides the law and the SPDC, the new law has brought significant changes not only to companies' policies and antitrust lawyers, but also to Brazilian society, economy and politics as a whole. Fortunately, such changes have been as positive as expected. Thank you.